I am Dean Schumitt, Jeff Schumitt, a professor of law and associate dean here at the University of Dayton School of Law. And I wanted to share with you a few benefits of the program, then give a bit of an overview of one of the courses, Constitutional Law, which is my favorite course in the program. And then I'm going to do a short sample lesson where essentially I'm giving you a sense of what it would be like to be in the class. Now, of course, it's not going to be a complete lesson. I'm going to try to keep this condensed so we're not keeping you here all day, but hopefully you can get a sense of what the courses would actually feel like. All right, so the non-degree program benefits here. I think the key benefit, of course, which has already been covered, is that it satisfies the U.S. legal education requirements for the DC bar exam. Now, of course, there are other requirements. The DC bar, if you're going to take the bar exam, you have to pass character and fitness. You have to have a law degree from your home jurisdiction, from China. There are other requirements, but the requirement that you have classes with a school here in the United States would be satisfied by this program, which I think is a very good program. It's a great program for a number of reasons. Let's go up to the top bullet point here. You have real-time online classes with full-time US law faculty. Normally, if you're going to take an LLM program, you're going to, as a foreign student, take law classes at a law school in the United States. You often get thrown into classes with everyone else, your normal JD students. And in my experience anyway, a number of foreign students get sort of lost in the mix. They have a hard time following along, and they struggle. With this program, it is geared towards students like you. We teach in a way that I hope is easier for you to understand, and we focus on really trying to get you ready for the bar exam rather than teach you, focusing on policy issues or other things that are not quite as relevant for the bar exam. In doing so, we try to give you multiple opportunities in each course for feedback on multiple choice questions and essays in key bar tested subjects. So hopefully this should be great preparation for you if you are planning to take the bar exam. It's a condensed schedule. We have an online LLM program on a normal traditional semester schedule, but a number of students like our format here. It's similar to an executive MBA. You can take all of our classes in just a few months in the summer and about a month and a half in the winter and be done within a year with the 26 credits that you would need to take the bar exam. Now, if you do well in the program, if you have at least a B average, which is not terribly difficult to do, but you will need to study and take the courses seriously. If you have at least a B average, you can get a certificate in United States legal studies. The certificate is really, it looks like a diploma, but it's of course not a degree, but it's something nice that you can hang on your wall that does in fact look an awful lot like a diploma. And perhaps more importantly, all of your credits will count towards the LLM degree if you would choose to go that route. So even though this is a non-degree program, these are graduate level courses and you could apply all of your credits towards an LLM degree. What that means is once you're done with this program, you could take one semester in our online LLM program and take a legal writing course and an intro to US law course and have your degree. Now, the degree itself, it's an online degree, so of course it would dovetail nicely with this program. It's a fully online degree. On the diploma, it doesn't say that or anything. It's just you're getting an LLM degree from a United States law school. All right, so how do we teach this course? These courses are taught a little bit differently than our JD courses here in the United States. In the JD courses, we're really trying to teach people how to think like a lawyer, those legal skills, as much as the doctrine itself. I'm going to try to do some of that during the program here, the non-degree program, but I think the focus is more on getting you to understand the rules that you need to know for the bar exam. I view that as the purpose of this program, to get you a good overview of US law. So there's some Socratic, there's some questioning back and forth like we do in our JD courses, but for the most part, I'm relying on these other things. There's a fair amount of lecture, and the lecture will be on the rules, on the law itself, on history, policy, all of those things to give context so that you understand the rules, the law a little bit better. Then we will review cases, right? The US system is really based on the British system. It's a common law system. Cases are all important. And so I will give you the law. We will then work through cases to understand how the court applies the law. Then we will take that from those lessons on the law itself, seeing the court apply the law. We will then work through hypotheticals, basically sample cases where we work through them together to get practice applying the law. We will then have practice essays at the end of every unit that will be very similar in structure and approach to the types of essays you're going to have on the bar exam. And in each course, or most of the courses, we're also going to work through an MPT exam, which I think is going to help you to, again, get those skills and the knowledge necessary for the bar exam. Okay, so that is the basic approach and setup of the program. And please interrupt me if you have questions. Feel free to type into the chat box or just start talking, raise your hand, whatever you want to do. So when you look at our program, we have 7 courses here to get the 26 credits. And each of those courses is a highly tested subject on the bar exam. Under the Uniform Bar Exam, or the UBE, there are 7 subjects that are double tested. What that means is there are multiple choice questions and essays on these subjects. My favorite subject, the one that I normally teach and write in, is constitutional law. So I thought for this sample, I would focus on constitutional law. And instead of giving you an overview, I'm going to give you a tiny overview and then go into one topic so you can see how this would work in the course. So constitutional law is really divided into 2 different topics. The first is the structure of the government, or government powers. We're going to walk through in the course the powers of each branch of the federal government, the judicial power, or the courts, the legislative power, Congress, executive power, the powers of the presidency, and then we will look at separation of powers and federalism, meaning essentially the checks and balances between those 3 branches and the powers of the state governments, the local governments. The second half of the course deals with individual rights. So rules that the government, rights that the government cannot infringe upon, basically limitations on government action. So there's the due process clause, that's fundamental rights, things like the right to choose, that's before the court right now with abortion. Gun control, also before the Supreme Court right now, Second Amendment. The right to refuse medical treatment, that's been a big deal with vaccines. So, a number of, I think, very interesting issues. Equal protection is the next topic. That is essentially discrimination. And we will focus on race, but also look at gender and sexual orientation. And then the First Amendment, which is freedom of speech and freedom of religion. Today, I thought we would dive into that first topic just a little bit of judicial power, the power of the courts. And I'm not going to start at the beginning because I think it's a little bit more difficult to pick up, and there's a lot of history in context that I don't think is great for this lecture. So let me just start by saying, as I'm sure you all know, courts in the United States have the power to declare laws unconstitutional. What that means is a court can say that a law passed by Congress or a state legislature, any law, is invalid, unenforceable, null and void. They can do that because the Constitution is seen as a higher law. So if there's a conflict between a statute passed by the legislature and the Constitution, then the Constitution must prevail. So judicial review is the basic power of the courts to say that laws are invalid. What I want to talk about, though, is this case or controversy requirement. This is a limitation on the power of the courts. This doctrine, the big picture here, is that federal courts can only decide cases or controversies. What that means is the courts can only strike down laws within the context of a legal case between two litigants. What they cannot do is render an advisory opinion. What they cannot do, what I mean by that is Congress cannot pass a law and then have the Supreme Court tell them whether it's enforceable. The Supreme Court is not supposed to be advising Congress or the president, and it does not automatically rule on the constitutionality of laws. Instead, it can only strike down a law in the context of an actual case or controversy. The reason we have this, the policy reason behind this, is essentially separation of powers. We don't want the courts to have too much power. If the court could decide legal issues outside of a case or a controversy, it would essentially be in control of the entire government. It would be just exerting too much power over Congress. It would be telling them what they can and can't do. It would essentially be at the top of our government. And that's not where the court is supposed to be, right? Congress and the president really have the most authority in our system. The Congress passes the laws, the president enforces those laws and sets policies, especially on things like foreign affairs. The courts are just supposed to be a check to make sure that Congress and the president do not violate their role in the system or violate individual rights. The court cannot be too powerful, especially because the Supreme Court is just 9 unelected individuals. So in a democracy, the people's elected representatives are supposed to be in charge, not just this one court composed of 9 people. So that's the policy in the big picture. Whenever we're dealing with constitutional law, there has to be some tie-in to the text of the Constitution. Now, the Constitution itself is a pretty short document. This, you can't really see it. There you go. All right, so this is a pocket Constitution. It's not very big, right? There's not a lot of text in there. So we're going to refer to the text, but the text doesn't usually give us much in the way of a clear answer or clear law to apply in specific cases. What the text says is the judicial power, so the power of the courts, extends to cases, different types of cases, right? Cases under the Constitution, the laws of the United States, etc., and controversies between states and so forth. And so the text of the Constitution says cases or controversies. It does not give the courts a power to really advise or command Congress unless it's in the context of a case. So that's the textual basis for this doctrine. Now, don't worry about all this stuff in the middle. In our civil procedure course, you will look at exactly what types of cases a court can take. That's jurisdiction, right? What types of cases do the federal courts have the power to hear? That's civil procedure. That's not something we delve into in constitutional law. So that's the big picture. Now we're going to break this down into specific legal rules. And there are 4 major doctrines that deal with this case or controversy requirement. We're going to look at the first one, that is what we call standing. Standing is asking whether the case was brought by the proper parties. That's really the focus of the inquiry. Is it a live case brought by the right people? Rightness and mootness ask, was the case brought at the proper time? Has it been filed too early or is it too late? And the political question doctrine, don't worry about that. That's the most abstract or difficult one, I think. It's asking whether this is a legal issue the court can actually decide. So we're going to focus on standing. In standing, we're asking, is this the right plaintiff? Is it the right defendant? So with any case or controversy, you have to have one individual filing a lawsuit and they're suing someone else, right? That's how it works. So a plaintiff, the person filing the lawsuit, must allege an injury, right? That's why they're filing a lawsuit, because they have been injured. Now, it has to be, we have to meet these three requirements. Number one, it has to be the right type of injury. It has to be an injury in fact, which means that it is both concrete and particularized and actual or imminent. Concrete and particularized, that means that it is something that actually affects the plaintiff in a real way, and it affects the plaintiff in a sort of unique way where it is not abstract or conjectural. It is something that is concrete. It is actual or imminent. It's happening right now, or it's about to happen right now. Second requirement is it has to be caused by the defendant, fairly traceable to the defendant's allegedly illegal conduct. It has to be caused by the defendant. We have to have the right defendant. And then finally, number three, it has to be likely to be redressed by the requested relief. Simply, the court can provide a remedy. The court can redress the injury. So the plaintiff has the right type of injury, it's caused by the defendant, and the court can do something about it. The court can provide a meaningful remedy. That's our basic rule for standing. And you might be thinking, I don't really understand what that means, right? What's concrete and particularized? What is fairly traceable? What does that mean? Well, the way that we get you to understand that, and the way that, the best we can do, because it's not a statute, it's not something that is written down with a complex test or anything like that. You have to look at the cases. The cases will explain what those rules mean and provide examples of how the court applies the rules. So by looking at these cases, we can understand what that test actually means, which is important. If you just memorize the black letter doctrine, the rule on that last slide, you're not really going to understand how to apply it. And application is key. The bar exam is all about applying the rules. They're not going to ask you, what is the rule for standing? They're not going to ask you, what is the third element? Instead, they're going to give you a hypothetical like this and ask you, what is the answer? Is there standing or not? Right? So you have to know how to apply the rule. That's what really matters come test day. All right, so I'm going to try to run through this quickly. I realize I'm spending a lot of time here. I'm sorry. So this is a famous case dealing with the standing doctrine. And I'm going to run through this very quickly. In class, we would spend more time on it. And I would give you more cases than just one, especially on a topic like this. All right, so this case is called Luwan versus Defenders of Wildlife. So just summary of this very quickly. The plaintiffs here are environmental rights organizations. They're essentially groups of people who want to protect the environment. They're advocates, lobbyists, and so forth who are trying to protect endangered species. They sue the federal government. Luwan is an official at the federal government. So they sue essentially the federal government, challenging the way the Endangered Species Act is being enforced. You don't need to worry about the particulars there, but essentially the Endangered Species Act, among other things, it requires the government to analyze whether any new project would harm an endangered species. So before the federal government builds a bridge, before they build a new water plant or a dam on a river, before they do anything that could cause an environmental impact, they have to have a study done that evaluates whether it would harm any endangered species. The way the government is applying that statute, though, they're only looking at the impact on endangered species for domestic projects, for things that are done within the United States. But of course, the United States spends money all over the world, and the government is not looking at the environmental impact before it funds foreign investment or projects in other countries. And so the plaintiffs are suing, seeking a order from the government, telling the government that they need to consider the impact on endangered species to all projects, even those in other countries. That's what they're looking for. All right. Going through the standing, that's the basic setup here. The court says the plaintiffs do not have standing, which means the court cannot hear the case. It's not a case or controversy. This is not the right plaintiff. These environmental rights organizations cannot file this lawsuit because they don't have an injury in fact. They don't have the right type of injury. They are not harmed individually, right? These are people who live in the United States who love animals. Well, they are not injured individually in a concrete way if an animal in another country goes extinct or the population is reduced, right? Think that the Asian elephant that I had on the picture in the last slide, well, there might be somebody in the United States who loves elephants, who takes great pleasure in seeing elephants and knowing they exist, but the extinction of the elephant is not going to actually cause them a concrete and particularized harm, right? That's injury number one. The court says the plaintiffs have to show that they are directly injured. The fact that their feelings are hurt is not enough. And injury number two, they try to take it a step further. The plaintiffs here, the environmental rights organizations, try to say, look, we travel internationally, we visit these animals, we like to see them, like going on safari, and they intend to continue to do that. But the court says that is not actual or imminent. That is someday in the future. The plaintiffs haven't shown that they live in those foreign countries, that they regularly study the animals. All they can show is someday they would like to go visit the elephant. Well, that again is not actual or imminent. It's not concrete. It is something that could happen in the future. That's not the type of injury you need to file a lawsuit. If you're going to file a lawsuit against someone, you need to actually be injured in a real way. Finally, the organizations try to say, look, we study these animals in zoos in captivity. And so we have a real connection to these animals. The court says, no, that is not an actual injury because it's not going to actually injure the plaintiff herself if the animal goes extinct somewhere else, right? If the animal goes extinct in Asia, that does not actually affect the zookeeper in America. The zookeeper in America still has that animal in captivity. Again, they might be sad. It might, make them upset, but that's not a concrete injury of the type we need to file a lawsuit. Finally, the court says, even if there were an injury, even if that first element of the test were met, there's no redressability, that third element. Remember, the court has to be able to provide a remedy. And the court here says there's no guarantee that they could remedy this situation. The plaintiffs are asking for this, they're filing this lawsuit because they want to save the endangered animals. But the United States funding isn't necessarily going to kill the animals. And if the US would, withdraw funding from a particular project, that wouldn't necessarily stop the project, right? These are foreign projects. And so if we withdraw money from a program somewhere, well, some other country might just donate more money, or the home country might invest more resources. And even if an environmental study is done, the US could even go ahead and study it anyway, or fund it anyway. Okay, so that again was a very quick, I realize, rundown of the Luwan case. Court says no standing. not the right plaintiff. What we would do next is go through some hypotheticals where we try to apply those rules to new situations to sort of see if we're getting it and get more practice. And many of these would be based on actual cases. So again, you're getting more practice with the cases. And try to get people involved in the discussion of why the right answer is the right answer and so forth. I think I've already hit my 20 minutes though. So I hopefully that gives you an idea of how the course would be run. It would essentially be going through this for each individual doctrine, right? I had on the slide different doctrines, standing, ripeness, mootness. Well, we would do a series of hypotheticals here, probably another case, more hypotheticals. We would then go on to the next doctrine. And at the end of the unit on judicial power, we would have a practice essay, and I would give you a model answer, and you could email your essay to me, where I could then provide feedback to you on that essay. So, I'd be happy to answer any questions you have about this, the topic itself or the program. And I'm going to type my email into the chat box so that if you have a question and it occurs to you later or whatever, you can always email me with any request you have. Thanks.